Right. As far as I can tell, we're live streaming, so I'm going to go ahead and call the case. Good afternoon, council. My name is Amy Klein, and I'm joined by Court of Appeals Judge Pickering and District Court Judge Kevin Smith, who's been appointed to sit with us by our Supreme Court. I'm going to call the case. We have one case on our docket today, which is case number 128-232, Kenneth Harris versus the state of Kansas. I will ask counsel to go ahead and announce your appearances. If Mr. Ott will do so, let me know how much time you'd like, if any, for rebuttal.
Assistant Solicitor General Ryan Ott appearing on behalf of the state of Kansas, and I would request 4 minutes for rebuttal, please.
4 minutes is granted. I will go ahead and set up that timer.
Thank you.
And then Mr. Welsh, go ahead.
Joseph T. Welsh on behalf of Kenneth Harris.
Thank you. Mr. Ott, you may proceed.
Thank you, Your Honor. May it please the court. In its prejudice order, the district court noted that KS's testimony was both heart-wrenching and compelling. But after it noted that, it glided over the remainder of the evidence and determined that there was not overwhelming evidence. It did so despite never, at least on the record, conducting a thorough analysis of all the evidence that was admitted at trial. But a review of this evidence shows that it was in fact overwhelming. And while the district court's prejudice finding as a whole was incorrect, the simplest path forward for this court is reversed based on the presence of overwhelming evidence. A 1507 movement cannot show a prejudice when the evidence against that movement was overwhelming. Here, as I just stated, the district court found that most of the evidence came from KS's trial testimony, and then it noted in its opinion that the rest of the overwhelming evidence came from a search of the septic tank. That is not the full picture of the evidence, for one, and two, in it doing so, it just providing the summary, it didn't fully engage with the KS's testimony as well as the remainder of the evidence. And if you were to look at all of the evidence at trial, even excluding Nurse Rich's testimony about a medical examination, the reasonable conclusion is that this evidence was in fact overwhelming, and such there's no prejudice to Mr. Harris.
Counsel, if you'll allow me to interrupt, I'd like to clarify. It's my understanding that the district court found Nurse Rich's, the same nurse's testimony was critical, untested, and untrue. And that in reading your brief, it seems to me that you agree her testimony was critical and untested, but the only issue you have is whether or not it's untrue. Is that correct?
I believe it was important. I would say it was not the center of the state's case or the center of the evidence. That would be KS's testimony. But I don't disagree that her importance that she found an injury to KS's hymen was not important. I guess I'm not entirely sure what the district court means by untested. Nobody had challenged it. I assumed that it meant that nobody really challenged the veracity of her findings, and I would agree with that. I would
because you agree that the defense counsel's representation in that regard was deficient. I mean, that was the court's finding, and you don't disagree with that on appeal, correct?
That's correct. I do not. The state does not challenge the deficiency finding on appeal. But the state does, Your Honor, disagree that it is untrue. Johnson testified that she found no evidence of trauma based on the pictures that she reviewed of the assault. In the state's opinion, this creates a difference of medical opinion. This would have created, if she had testified, would have created conflicting medical testimony that would have required the jury then to determine credibility. And then based on the overwhelming nature of the rest of the evidence, even if the jury did not believe that the same nurse's testimony or the same nurse's findings of the presence of an injury to KS's hymen was correct, they still would have convicted on the counts that they did convict Harris of. Yes.
Counsel, was the same nurse's testimony challenged in any way at the district court before at trial?
The trial counsel conducted cross-examination primarily, or at least Beam's cross-examination was asking about a 2006 exam. He did ask her some details about what she found, but he did not challenge her methods, no.
They're more clarifying questions, correct?
Yes, they were more clarifying questions. The defense counsel's theory at trial was that KS was sexually assaulted, but it wasn't by Mr. Harris, so his focus was not on challenging her findings.
So why doesn't the fact that we've got an independent witness, the same nurse, testifying that she found physical evidence of abuse and that wasn't challenged before the jury, why does that alone not create a reasonable probability that we would have a different result here? Because that's really all we're looking at, correct? Whether there's a reasonable probability of a different outcome?
Yes, that's what we're looking at here.
And you're looking at the victim's testimony, you're relying on the victim's testimony?
Not just the victim's testimony. Yes, her testimony is primary, as well as her forensic interview, which is largely consistent. I'd say it's certainly not contradictory. It repeats a lot of the same details. Additionally, she supplied law enforcement with a bloody tampon. KS was prepubescent. She had not yet had her period. And she had testified and in her interview talked about how Harris made her use tampons to cover the bleeding so he wouldn't get caught. That tampon tested positive for her blood. And again, she was prepubescent. She had a condom wrapper that she had testified that he used condoms every time he raped her. She had a condom wrapper. They did a search of the septic tank and they found condoms, which she testified he flushed down the toilet, condom packages, parts of condom packages from a convenience store, and tampons. Those condom packages matched the package that she provided with law enforcement. And then testimony also showed that he had frequented that convenience store in Moscow where those, which also sold the same condom brand. And then additionally, his former stepdaughter, PP, provided 455 testimony about him sexually abusing her from the ages of 7 to 12 and the ways in which he did so. So it's more than just KS's testimony, which I think I agree with the district court. It's both heart-wrenching and compelling and provides several details about his sexual abuse, but it's the corroborating evidence as well. The nurse's testimony, while I don't disagree it was important, was just a piece of the puzzle that corroborated KS's testimony about Harris' sexual abuse of her.
Mr. Ott, I'm going to interrupt you for just a moment. You mentioned part of the overwhelming evidence was the forensic interview. Is that correct?
Yes.
And at trial, the attorney never cross-examined at all the forensic interviewer. Is that correct?
That is correct.
So when you include it in your overwhelming evidence, you acknowledge there was no cross-examination.
I do acknowledge it, but
okay.
I also would like to say to that Judge Pickering that while the district court did find that a deficient performance, but not prejudice.
Right. I'm aware of that. I'm just saying in part of your overwhelming evidence, you acknowledge it was never cross-examined.
Yes, I acknowledge that, but I would also point out, as I said earlier, that it was largely consistent with KS's trial testimony. And so I think it provides good additional evidence to show that her story was consistent through her recounting of it, that her discussion both of the instances of him raping her, as well as using a board and a gun to threaten her and threatening to kill her, her stepmom, and her animals if she were to tell anybody, as well, and her discussion of both the use of the tampons and the use of the condoms, that the interview supports her testimony.
Yes. Isn't it conceivable that the nurse's same testimony could have potentially impacted weight and credibility of not just the same nurse, but also the victim, also the other witnesses potentially? I mean, it has the potential to impact credibility, doesn't it?
Yes, Your Honor, it has the potential, but just having potential is not the standard here. It must be a reasonable probability, the probability must be sufficient to undermine the outcome. And here I don't think that is met when you look at all of the other evidence, as well as the same nurse did testify about her exam. She also testified about meeting with Chaos and doing like a narrative interview to establish the facts. And that's something that Dr. Johnson actually complimented on, said she did really well of. And that narrative interview with Chaos included Chaos again recounting that her father was the one who sexually assaulted her.
Mr. Ott, you would agree. I apologize for the echo. You would agree that PP's description of the 5 years of sexual abuse by her father differs quite differently from what KS says in terms of the mode of abuse. Would you agree?
For the most part, yes. In that PP did not testify to him penetrating her with his penis. She did testify to sexual touching, I guess would be, for lack of a better term. Chance in her testimony did discuss some of that. She talked about how Harris made her put her hand on his penis in the hot tub. So there is some similarities, but the main accusations from KS, that being instances of rape, were not present from PP's testimony. No.
But it still shows a propensity.
Yes,
to sexually children of that age.
Not just sexually children of that age, but people who are his family member, his daughter and stepdaughter. So people who are under his care and protection, or in his house, who are family, and who are also girls of that age. Yes.
All right, counsel, I have your time, unless one of the other judges has a question. I believe that will be your time if you want to still reserve your 4 minutes for rebuttal.
Yes, Your Honor, I'd like to reserve my 4 minutes for rebuttal. Thank you.
Any other questions, Judge Smith or Judge Pickering? Okay, thank you. All right, Mr. Walsh.
May it please the court, I want to advise the panel that I appreciate being able to bring this case in front of it. I first became involved with the case in 2019. And I also want to let you know I'm also terrified to be in front of you. This is my first time in front of a Court of Appeals panel since I was a third-year law student, and that was quite some time ago. In this case, the jury was affirmatively told by the state that the SANE examination showed trauma in various stages of healing, and that trauma was consistent with repeated abuse. The state then used that medical claim to reinforce KS's testimony because the injuries that they were told existed should not have been there. And the state bolstered KS's credibility with the medical evidence that was admitted unchallenged in any meaningful way. When we went to the 1507 hearing, Dr. Jennifer Johnson, who teaches SANE nurses how to conduct the exams, and Nurse Jessica Albers, who was also called by the state, and she likewise teaches nurses how to conduct the same exams, they both reviewed the photographic evidence that was obtained, and both testified that they could find no hymenal injury or trauma in the photographs that Nurse Rich was relying upon, the nurse who conducted the same exam. And so the state used the SANE exam as a building block to bolster the credibility of KS. And Judge Ambrosier, in arriving at his decision that prejudice existed, found that linkage and the use of the medical testimony as a building block for KS's credibility, that created a reasonable probability sufficient to undermine confidence in the verdict. And as a result, he granted a new trial to Mr. Harris. Uh, Mr. Harris thinks that Judge Ambrosia hit the nail on the head when he wrote the decision with regards to part one and with regards to part two. Specifically, Judge Ambrosia made credibility determinations with regards to trial counsel who was called by Mr. Harris to testify at the phase one 1507 hearing. And Judge Ambrosia found that trial counsel was not credible when it came to what trial counsel said he did with regards to conducting an investigation to determine whether he needed an expert or not. I believe that the state has accurately stated that with regards to with I apologize. The state has accurately stated that when it comes to the excuse me, let me back up a moment. Judge Ambrosia made a determination that when it came to trial counsel's testimony regarding his consultation with his physician brother-in-laws, that he did not find that to be credible. He also did not find that to be sufficient, even if that testimony was credited. And so when we look at what trial counsel did in this case, the state accurately states that trial counsel went to trial in the case not knowing whether the report that he was relying upon to make the decision that there was some type of trauma and it existed, and his sole position was Mr. Harris didn't do it. That whole trial strategy was flawed, and that whole trial strategy was flawed because counsel failed to even do anything really to investigate the medical evidence that was going to come into this case at trial. And
Counsel, what about the state's argument that even on your best day, you go back, you don't have the same nurse's testimony, and you have the new testimony that there's no evidence of trauma. We still have the admission that this is basically a neutral finding, that you don't have to have evidence of trauma, and there often isn't. And so does that lessen the impact of and the prejudice here?
I don't think that
the same nurse's testimony?
I don't think it lessens the prejudice, but if you're asking, is there other evidence that supports the verdict? The answer is yes, but there can be other evidence that supports the verdict, and there can still be a reasonable probability that the verdict was undermined by counsel's failure to do two things. Those things are not mutually exclusive. We're not saying that there was insufficient evidence to support the convictions. That's already been determined. What we're saying is that the evidence that was used to convict Mr. Harris, that had a proper investigation been done by trial counsel, that trial counsel would have retained an expert, consulted with an expert, learned about the report, obtained the photographs that trial counsel never even reviewed, and would have put on evidence to the contrary with regards to that. And I believe.
But I guess I'm looking at the meaning and the impact of that evidence. And if the ultimate impact is only a neutral finding, how does that impact, or does that impact our prejudice determination here? Does that make sense?
Is what you're asking is how is the evidence prejudicial?
No, I mean, and I apologize if I'm not phrasing it correctly, but it seems to me that on your best day, the evidence the only evidence you would have is there's no evidence of trauma, but that doesn't necessarily mean it didn't happen, correct?
Well, that's not exactly the case because of the way the case was tried and how the evidence was used at trial. The evidence was not limited to just medical evidence. The evidence was used to bolster KS's credibility at trial, and it's pretty doggone difficult to determine how that plays out when you kick out a huge block that they had relied upon and made a whole lot of hay out of during the trial. When that block is no longer there supporting KS, the jury's not necessarily going to give the same credibility determinations to KS in that regard. So it's not like it's cordoned off into one specific area of the trial. And okay, if we eliminate that, it's we uh, we've disinfected the trial and now it's all good. That's not the case.
What's your response to the state's argument that, in the way I interpret it, is the state is basically saying the same nurse's testimony was kind of a belt and suspenders credibility support because there was other evidence, independent evidence, that also supported the victim's credibility, such as the consistency of her testimony and the forensics interview, such as PP's testimony, and then all those items that were found, in the septic tank, and then also her production of the tampon. I mean, it sounds like they're arguing we have all this other stuff that still supported her credibility. So even if, the suspenders of the same nurse support went away, we still had enough to support that credibility. What's your response?
My response is that there is significant evidence to support the verdict, but it's not overwhelming evidence. And I'll also point out that with regards to the condom that was found in the septic tank, that the KBI agent went to a place called the Store in Moscow, Kansas, and bought a condom and then compared the lot numbers. But nobody ever asked the question of when that condom dispenser was restocked. So the state linked the condom that they bought from the store to a condom wrapper that they found in the septic tank. And if that occurred, if defense counsel had simply asked, well, when was it restocked, or attempted to get the records to determine that, that is potentially exculpatory evidence, because it may turn out that the thing was restocked after Kenneth Harris was already in jail, because the search of the septic tank and the purchase of the condom doesn't happen for 3 to 4 months until after Kenneth Harris has already been incarcerated. So I don't think all the evidence is necessarily supportive, as the state claims, but by the same token, I'm not going to minimize it. The court reviewed KS's testimony, the district court did, and found it heart-wrenching. That's significant testimony. The district court didn't minimize that either in its order. I think the district court was really torn in making its decision because of KS's testimony. And so I'm going to say there is other evidence, such as the tampon, and there is KS and PP's testimony, and that's significant evidence, but that it's not overwhelming evidence. To get to the overwhelming point, I think Judge Ambrosia is right. You have to have the same nurse there, and you have to be able to link KS's testimony to the results from the exam.
Thank you.
I would, I guess I would also add that with regards to the district court's determinations, the actual factual findings, that Judge Ambrosia had an opportunity to review Dr. Johnson's testimony live He had a chance to review Nurse Albert's testimony live. And I don't even think if there had been that testimony at the trial that it's side by side testimony like the state maintains. In in had he done it, had trial counsel done an investigation, he would have learned that the protocols for admitting a SANE exam require the alleged victim to be photographed in two different positions in order for a finding to be made in the first instance. And uh, Nurse Rich did not do that when she conducted her SANE exam. So any findings from the SANE exam were deficient to begin with. And had they been subject to a Dauber hearing, probably would not have been admissible had Dr. Johnson been called to testify and had Nurse Albers been there to testify as well. I don't think that Nurse Rich's report and findings would have even been admitted at that point.
So,
Counsel?
sorry, Mr. Walsh, to interrupt you. So are you saying both the protocol and the findings of the nurse were in question?
That's correct. Both are.
And therefore, it may not be a battle of testimonies between the two, as the state alleges, because one may just not be credible at all, given the lack of following the proper protocol.
One may not have been admissible at all, but because of the lack.
Admissible.
Yes. And I want to raise
sorry, before you get started, I have another question about kind of the impact of the evidence. It's my understanding that the defense at trial was that abuse may have occurred, but it wasn't your client. Is that correct?
That's correct, Your Honor.
And so if your client's defense is really dependent on identity and not disputing the fact that abuse occurred, doesn't that also undercut the significance of the same nurse's potentially incorrect testimony?
I'm sorry, of the same nurse's what?
Or potentially incorrect testimony. Doesn't that undercut it? If we're not really disputing whether abuse occurred, and that's what her testimony really related to, if we're just talking about identity, then doesn't that undercut the significance of the impact of her testimony?
I don't think so at all. When it comes to the sane nurse, when it comes to the sane nurse's testimony, she finds that there is trauma, and if there's trauma in the findings, then trauma has in fact occurred. There's that, and when KS comes on top of that and says trauma occurred, that immediately bolsters KS's position at the trial.
But it doesn't bolster the identity of the perpetrator, I guess is my point. And isn't that really what the defense focused on below, is identity of the perpetrator of the abuse?
The defense didn't focus on anything below, Your Honor. If you look at the record, there's no objection throughout the whole 2-day trial. I can't even get through a 20-minute hearing without making some objection of some sort. In addition, there's no cross-examination of the individuals who did the forensic exam. There's a 7-question cross of the medical expert. There's no opening that occurs. It's waived at the start of the trial, and then counsel doesn't do it later. Those are things that, why they don't rise to the level of being entitling Mr. Harris to a reversal of a trial, they certainly reflect on how this case was tried, and the effort put forth by trial counsel in trying that. So to say trial counsel did much at trial, it's hard for me to get there. But I did want to address the fact that the other issue that the court found existed was that trial counsel was deficient in failing to conduct an investigation into whether to have an expert come in on the forensic interview. And
correct. Counsel, you are out of time, so I'll give you a minute to wrap up, but you have
Okay.
used up all your time. We asked you a couple of questions, so I'll give you a minute to wrap up.
Okay. And so with regards to the forensic interview, that was never challenged, and that's important. And I think that the court, and I believe Judge Ambrosier should have considered a cumulative error review to consider that as well. And we're also challenging whether there's prejudice on that or not. And I cite to the additional authority that I provided the court earlier. Thank you, Your Honor.
Thank you. Mr. Ott?
Thank you, Your Honors. First, just briefly, I want to note about whether the condoms being restocked, the opposing counsel brought up, it wasn't asked about. That was not found to be deficient performance. And so whether defense counsel should have asked that question on cross-examination is not really relevant to whether or not that is additional supporting evidence. Judge Klein, I also wanted to note that you were correct about even if the same nurse didn't testify at all, or if Dr. Johnson had testified as she did at the 1507 hearing, the best that Harris would have gotten out of that would have been a determination that there's no finding of injury, which is neutral. It does not mean that no sexual assault occurred.
Mr. Ott, I do have a question on that. Mr. Welsh, states that is more important than just evening out the playing field in terms of whether there's injury or not. He began his oral argument by stating that this bolstered KS's statements and her testimony. So what is your response to that argument, please?
My response is that it wasn't used to bolster. I would fully acknowledge that when a victim testifies that she was sexually assaulted and a nurse testifies that she found that does support her testimony, but it's not bolstering. And I'm glad you asked that question, Your Honor, because the next thing I wanted to talk about was Mr. Welsh talking about that, and the district court in its prejudice finding quotes a portion of the state's testimony where it's discussing the same nurse's testimony, and states that portion was indicative of the state's theory and how it approached the case. And that's incorrect. That quoted portion is taken out of context. The theory of the case, the state's case, was not centered around the same nurse's testimony. It was centered around KS's testimony. And if you look at the full context of the closing argument, you'll see that it is just a paragraph and a line of discussing all the evidence, starting with KS's testimony and then her forensic interview, and really focusing on those, and then going into the remaining evidence, the investigation, the tampon, the condoms, the septic tank, and then yes, as well, Nurse Rich's testimony. So yes, it was used to support KS's allegations, and well, obviously, a finding of an injury supports the allegations of sexual assault, but it was not used to bolster her testimony, and it was not like the central focus of the state's argument and state's theory of the case. And just one more point I'd like to note is that a defense counsel testified at the deficiency hearing. The reason he did not do an opening argument is because he was not sure if Harris would testify at that point or not. Harris had talked about wanting to testify, but it wasn't determined for sure. And so he didn't want to get up and give an opening talking about things Harris would say and then have him not testify. After the state rested, it was determined Harris decided not to testify. And so, again, he didn't put on any evidence because his theory was that somebody else, he didn't have Mr. Harris had decided not to testify, exercised his constitutional right not to testify, I should say. And so he waived his opening before he rested as well.
Mr. Ott, sometimes defense counsels don't know if their client's going to testify at all until the state's closing, and yet they still do an opening statement.
Yes, that's correct. But he chose not to, which is within his determination as for a trial strategy. And I would also note along with that the trial counsel did not find him deficient for deciding not to give an opening statement.
In fact, this is a softball question. In fact, sometimes defense attorneys find it better not to do an opening statement. Is that right?
That's correct. In fact, sometimes defense attorneys decide the best thing to do is not do an opening statement or present any evidence at all. That is within strategy, and it's well within the defense team's right to not do that. It's entirely the state's burden to put on the evidence sufficient to convict. The defense counsel doesn't have to give an opening statement and doesn't have to put on any evidence to prove that his client was not guilty. If there are no further questions, the state would just ask that this court reverse the district court. Thank you.
Thank you both. We really appreciate the thorough briefing and the very detailed arguments today, and we will issue an opinion as soon as possible. Thank you.
Thank you.